Court-martial bloopers, part 8. So this one involves an argument by a government counsel, or an objection rather by government counsel. So there's different stages of the proceedings, lots of different objections that you can make at various times that might be appropriate, it might not be appropriate. When someone's making a closing argument, one of the objections that you might make is that they are arguing about information that never came out in the trial, right? During questioning, you might object to relevance. You might object to it being beyond the scope of the examination. You might object that it violates one of the notice rules. You might object that it is speculative. Objection, speculation. Objection, argumentative, right? There's all these different objections. It's really important to know what stage of the proceedings you're in before you lodge an objection, or you might just make an ass out of yourself. So there was a court-martial out of Fort Cavazos, formerly known as Fort Hood, and I had just arrived. It wasn't my case, but I was in the gallery and I watched it happen. And the military defense counsel was giving his opening statement where he's talking about an outline of what he expects the evidence will show, because the trial hasn't happened yet, but he's talking about what is going to happen. And in the middle of his opening, the prosecutor stands up very confidently, and says, "Objection, facts not in evidence." At which point, the very patient military judge looks over and is like, true, there are no facts yet in evidence. Objection overruled. And prosecutor kind of slunk back down. Messy military lawyer.